Hello, this is Kevin Thompson. I'd like to welcome you to the Davis McGrath LLC IP webinar series for February 6, 2013. Today's topic is trademark dilution. Today we're going to be going for about 30 minutes. The recording and slides will be posted on the address here on your screen, which is blog.davismcgrath.com/webinars, where you can also sign up for our webinar mailing list. For those of you who need Illinois MCLE credit, if you haven't already done so as part of the registration process, please send your name and ARDC number to me. For people viewing the recording, please also send me your name and ARDC number and when you viewed the recording, and we will endeavor to get you credit. Our next webinar is coming up on March 13th, 2013 from 12 to 12:30, again for about half an hour on the topic of debunking copyright myths. So today we're going to cover trademark dilution, look at a little bit between federal versus state protection, go through the different provisions of the Dilution Act, which is 15 U.S.C. 1125, and then definitions, exclusions, remedies that are available for trademark dilution, some changes that happened in the 2006 Act, and then we're going to go through some cases and talk a little bit about some interesting cases that have cropped up over the past few years dealing with trademark dilution. But first, probably the easiest way to sort of get into dilution, because it is different than regular trademark infringement, is to talk a little bit about just what it is and provide an example from a case. Just imagine that you're the owner of Louis Vuitton, and Louis Vuitton sells handbags with this very distinctive design elements as part of it. They're expensive handbags, and it is a brand that's, I would say, famous. It's well known. But at the same time, somebody's come along and made what's a parody, ultimately found to be, but it's a chewy dog toy, and it is in the shape of a handbag, and they call it Chewy Vuitton as opposed to Louis Vuitton, and it is also has a regular series of designs across the face of it. And the Louis Vuitton folks saw that, and they were not very happy with it. The question is, what do you do about it? You know, is it trademark infringement? No, these aren't selling it for handbags. It's not, you know, a direct infringement of their mark. But what it does do is it tends to harm the reputation of their mark, and that people may laugh at them. People may, you know, hold them up to some ridicule, and so this Chewy Vuitton brand, something has to be done about it. Well, what to do about it? Well, that they decided to bring what we call a trademark dilution case for it. What's called dilution by blurring, in which you which we'll talk about a little more detail here. There's two different types. Dilution by blurring is where you there's some you know, distinction between the two marks, but you know, there is enough of a relationship between the two that people think that you know, the line between the two is blurred. Trademark by dilution by tarnishment is where you harm the reputation of the mark, and we'll certainly talk about those in a little more detail and go through some of the definitions that are there in the Act. So anyways, this is a real case. It's Louis Vuitton Malatier versus Hot Diggity Dog, which is a 2006 case. And ultimately, just so you know, this was found to be a parody of the Louis Vuitton bag, and as such, you know, was protected as a parody, and was not, you know, not found to be, you know, dilutive. But that certainly was one of the claims that was made by Louis Vuitton, and so it's certainly a good example that you know, for discussion here today. it should be noted that protection for dilution is a mix between state and federal protection. Over 40 states have their own dilution laws. The Illinois Act can be found at 765 ILCS 1036/65. It should be noted that the federal law, which is 15 U.S.C. 1125C, does not preempt state law. But at the same time, if you have a federal registration, it does act as a complete bar to an action based on common law or a state registration. The whole purpose of having a federal registration is a sort of quiet title to a mark across all 50 states, and so that's a a purpose of the Federal Registration Act, and so you still could be liable for a dilution claim brought under the Federal Act. That's certainly possible, but it does act as a bar to an action based on common law or a state registration. So here's the operative section of 15 U.S.C. 1125C, Section 1. So spend a few minutes going through here. It's the subject of the principles of equity, the owner of a famous mark that is distinctive, and that's the first definitional element. It has to be a famous mark, and then that distinctiveness comes either inherently or through acquired distinctiveness, shall be entitled to an injunction against another person who, at any time after the owner's mark has become famous, commences use of a mark or trade name in commerce that is likely to cause dilution by blurring or dilution by tarnishment of the famous mark. And we have talked a little bit about dilution by blurring and a little bit already about dilution by tarnishment, but those are defined later on in the Act. Regardless of the presence or absence of actual or likely confusion, of competition, or of actual economic injury. So that's the important section of the Act, and it guides the rest of our discussion here today. Like I said, the first major element of it involves a famous mark that is distinctive. There's no registry of famous marks, so just what is famous, and there's a section that deals with that. Then it deals with somebody using a mark or a trade name in commerce that is likely to cause dilution. This is a change from the prior Act. This is it merely has to be likely to cause dilution. And then there is one cause of action for dilution by blurring, another cause of action for dilution by tarnishment, and then what's important to note is the last section here is that both of these claims they can be brought regardless of whether or not there is any actual or likely confusion or competition or of actual economic injury. You don't have to wait until your mark is severely damaged before bringing a dilution claim if the mark that is being introduced is scandalous or tarnishing to your mark. So let's go through some more of these definitions here. Just what is fame? A mark is famous if it is widely recognized by the general consuming public of the United States as a designation of source of the goods or services of the mark's owner. And then there are four factors that the courts will look at to determine whether or not this mark is got the right degree of recognition by the public. The first thing to look at is the duration, extent, and geographic reach of advertising and publicity, whether it's advertised or publicized by the owner or by third parties. So you might look at marketing efforts of the owner itself, and then in this days social media, you might look at third-party use. People are talking about your brand on Twitter or on Instagram or other services or Facebook. Then that could show fame or recognition of your mark by the general public. And then you look at the amount, volume, and geographic extent of sales or goods or services after another mark. Anything that you can show the extent of actual recognition of the mark, or whether its mark was registered under the prior acts or whether it's currently registered on the principal register. And so that's a little bit goes into whether a mark is famous or not. The next section goes a bit definitionally into just what is dilution by blurring. And we talked about this briefly, but here's the definition that's in the Act. It's association arising from the similarity between a mark or trade name and a famous mark that impairs the distinctiveness of the famous mark. And then there are 6 factors that the court will need to look at. Well, first is the degree of similarity between the trademark or mark and the famous mark, the degree of inherent or required distinctiveness of the famous mark, the extent to which the owner of the famous mark is engaged in substantially exclusive use of the mark, the degree of recognition of the famous mark, whether the user of the mark intended to create an association with the famous mark, and then any actual association between the mark or trade name and the famous mark. And so these factors are all parts of this analysis. We'll talk a little bit about the changes that were brought out by the 2006 version of the Act. But this is one of the significant changes. It moved one of the definitional elements that used to be required as a foundational element for bringing a claim into part of these factors. Which was, the degree of similarity between the mark and the others, and it certainly changes the scope and focus of the Act, and it makes it a lot more friendly for a trademark owner, to bring this type of a claim. And next section is a definition of dilution by tarnishment, which is a lot shorter, which is any association arising from the similarity between a mark or trade name and a famous mark that harms the reputation of the famous mark. And there are no factors given here. Instead, I think that leave it up to the facts of a particular case. You can certainly claim something is tarnishing, and court will look at it, and evaluate it. And ultimately the finder of fact will determine whether or not something is truly tarnishing the reputation of the famous mark. So that this particular definitional section is a lot shorter. Now, this section deals with exclusions, and there are certain things that cannot be actionable as dilution by blurring or tarnishment, and that would be fair use, sort of either nominative or descriptive use of a famous mark, such as advertising or promotion that permits consumers to compare goods or services, or identifying and parodying, criticizing, or commenting on the famous mark owner or the goods or services of the famous mark owner. And so this, the revised Act certainly, preserves the ruling from the Louis Vuitton and Chewy Vuitton case we talked about at the beginning. The hot diggity dog case, in which the use in the dog toy was found to be a parody of the mark, and so certainly they were not using it in such a way to like on handbags or something like that to directly compete, and this parodying was something that was protectable and should go forward. So that's Section A. Section B would be form of news reporting and news commentary. That would be protected as well. That cannot be action for blurring or tarnishment. And same with any non-commercial use of a mark. Now, if you're able to prove that something has caused either caused dilution by the blurring or tarnishment, this definitional section itself, C1, provides for an injunction. But there are other remedies available as well. If it was willful infringement, willful dilution, and the dilutive mark was first used after October 6, 2006, you can also get profits of the infringer, actual damages of the plaintiff, and costs of bringing the action. And so certain cases, if it's an exceptional case, you may be able to get attorney's fees as well. It really will depend on the facts, but that's certainly a possibility. The 2006 Act, it revised the 1996 version that was operative under the Louis Vuitton case. No longer requires actual dilution. Standard is now likelihood of dilution. And it used to be before you actually had to prove that there was actual, dilutive effects. But that's all it has to now is it has to be mere likely. Eliminates niche fame. In other words, it used to be that you could just prove that your mark was famous within a small subset of the consuming public, and that would be enough to be able to bring a dilution act. Actually, no. Now you actually have to show that the general public would become to recognize your mark. And then the 2006 Act explicitly includes dilution by tarnishment. There were some before that had not. It looks like we've got a question. The question is, does the Federal Registration Act as a bar to an action under state registration or common law, even if the date of the state registration is before the federal first date of use? And that's a question that I don't know the exact answer to. I will certainly look at that and get back an answer to you. I suspect I know the answer, but I don't want to guess and give you the wrong answer here today on the webinar. I will certainly get back to you with the answer. I should also note that at any point during the webinar, if you have questions, please feel free to ask them. I'll do my best to answer them as we go along, and also we will have a question and answer session at the end. So now we're going to get into some discussion of the cases. The first is a rather interesting one, Starbucks Corporation versus Wolfeboro Coffee. We'll first talk about the 2009 decision in this case. Just so you know some of the background here, Starbucks Coffee is a famous brand for coffee. They've got thousands of retail locations across the United States. I think people would generally come to say that Starbucks is indeed famous. And they were not too happy with a micro roastery. The Wolfeboro Coffee is doing business as Black Bear Micro Roastery, and they have a brand of darkly roasted coffee called Charbucks. And they would sometimes advertise that as Charbucks Blend, and Charbucks or Mr. Charbucks is sometimes how it would be, appearing on product packaging. In the original case, the marks were indeed somewhat similar, but the lower court, decided not to allow the dilution claim to proceed. So Starbucks brought an appeal to the Second Circuit. There was a finding that the marks were somewhat similar but not substantially similar. Starbucks versus Charbucks. There are similar, but not that close. Certainly sound similar, but that they're not exact. Now, the amended dilution statute, did not require substantial similarity. It merely moves, that requirement down to one of the factors of whether or not there is a, dilutive effect. The statute allows the degree of similarity between the marks, to be a factor in the analysis. One interesting fact was that, Black Bear chose the mark deliberately for there to be an association with Starbucks. It wasn't just a mere coincidence, that they was more of a commentary. So some people think that, Starbucks over-roasts their coffee, and at one point, it comes out in the case that Charbucks is a derogatory term that's sometimes used to make fun of Starbucks, and so here comes along somebody making a Charbucks blend, and so at one point Starbucks tried to claim tarnishment as well, by this, but neither the district court nor the Second Circuit bought that particular argument. They rejected that tarnishment claim because the Black Bear product was a high quality blend, and was actively promoted by Black Bear, and there was no showing that it actually harmed the reputation of Starbucks in any way. But the interesting part was they remanded it for a determination of whether or not there could be dilution by blurring. The lower court really didn't go through and analyze the factors as well as the Second Circuit would have liked, and so it was remanded back for a further determination. And so on remand, which is now the decision we'll be talking about from 2011, I've got the site down here on the bottom of the screen. The lower court, found that the marks still are indeed somewhat similar, but Black Bear's primary mark that's used to advertise the blend is its Black Bear brand. Charbucks is merely used as the varietal name, the particular kind of coffee. And it's always used in conjunction with it. You'll never find, a Charbucks blend used solely by itself on the packaging of coffee. Instead, the prominent mark that's used on the packaging is the Black Bear. And so, even though there are these bad facts, such as, the fact that the Black Bear chose the name deliberately to be associated with Starbucks, these are only loosely associated. So they've all together found that the Charbucks is not likely to impair the distinctiveness of the Starbucks mark, and so ruled in favor of Wolfeboro Coffee, who's operating as Black Bear. I thought that was sort of an interesting discussion of that dilution claim. So let's move on to our next case, which is some of you may know that the reason that we have a 2006 Act is there was a 2003 Supreme Court case between Victoria's Secret and the Mosleys, who operate Victor's Little Secret. Victoria's Secret, as most of you probably know, is a lingerie company, and Victor's Little Secret was a small adult merchandise company. They sell all sorts of variety of sex toys and things of that nature. And so Victoria's Secret brought the action against Victor's Little Secret to as a dilution claim, as claiming the tarnishment of their mark. And so the original case came out, was found not likely, to cause this, cause dilution. The Supreme Court, found in favor of Victor's Little Secret and, remanded it for further determination, consistent with its opinion. In the meantime, Congress goes about and, amends the Dilution Act in a fairly substantial way since then. Meanwhile, this case is still proceeding. There's a lower court decision in which applying the new act, they find tarnishment between Victor's Little Secret, for its adult merchandise, and Victoria's Secret for its lingerie, saying that Victor's Little Secret, would tarnish the reputation of Victoria's Secret. And so it went up to the Sixth Circuit in 2010. This was sort of interesting. The question, one of the questions in the case is, whether or not, this new law that was amended, should be applied. Because obviously it had already been up to the Supreme Court once already under the old act. And in this case, the Sixth Circuit ruled that it was okay to apply the new law because, you know, the regulatory authority here, in this case Congress, had changed the law in a substantial way while the case was still pending. And also, it was okay to apply the law retroactively when there was relief sought for ongoing conduct. And so, you know, this ongoing conduct was happening. You know, the Victor's Little Secret was still, you know, selling its wares, and, you know, as far as Victoria's Secret was concerned, you know, tarnishing its brand. And so, you know, the lower court found tarnishment, and that was upheld by the Sixth Circuit. So this judgment was affirmed in favor of Victoria's Secret. And interestingly, they tried to appeal again to the Supreme Court, but cert was denied. So I do believe this case is finally over. For those of you that, you know, were following it from the Supreme Court case, you may not have been aware that, you know, this was still, you know, undergoing litigation, but it certainly was, and, you know, has gone on from there. The next one is also kind of an interesting one. This case involves the trade dress design of the pocket design shown on the back of jeans, and this is a case between Levi, Strauss, and Abercrombie and Fitch from 2011. The lower court ruled in favor of Abercrombie, and then you know, this particular decision is the Ninth Circuit, you know, review of that, you know, lower decision, and in this case, they tried to argue that you know, that the lower court had, you know, applied the wrong standard. The Levi Strauss had put forth survey evidence to show that consumers would be confused between the two. They've got this distinctive, what they think is distinctive, this what they call the arcuate, which is the two arcs that come together to form, you know, the design on the back of the pocket. And at the same time, Abercrombie and Fitch, using the design on the right, they've got two things that come together and also form an infinity symbol together. And the original jury instruction asked whether or not the design was identical or nearly identical to Levi's trademark. The problem is that particular standard is not in the 2006 Act, in which, you know, just merely says, are they, you know, are they similar? And you know, which is now just one of the 6 you know, factors. And so you know, the Ninth Circuit found that it was not harmless error in having that jury instruction asking for this higher standard of being identical or nearly identical, and merely, you know, should have been just one of the factors looked into. How similar are these, you know, two designs? And so in 2011, it was reversed for a determination of whether or not there has been dilution by blurring. And as far as I know, the case has not yet been decided. So I don't know if it's still even proceeding, you know, whether or not it's you know, settled out or not. But that's the reported decision is a reversal, you know, for that determination. And then our last case is an interesting one. It's a little bit of an older case from 2007. The dispute over between you know, companies in the cleaning industry. ChemDry is a famous mark for dry cleaners and carpet cleaners. You know, they you know, do a lot of dry cleaning chemicals. And at a trade show, their competitor Leiden produced a T-shirt which made fun of ChemDry, and it was Chem Who ? And then used a tagline on it, "Sticking it to the little guy." And so they weren't very happy that they were, you know, being made fun of at the trade show with an almost identical use of their mark. It's got the same, you know, chem, you know, prefix. It's got this sort of a line, a slash that goes up to the right, and then instead of the word dry, it's Chem Who ? And then you know, long use this tagline saying that they're sticking it to the little guy. And so this, sort of derogatory T-shirt, was sort of snatched up by ChemDry people and became the basis of a cease and assist letter, which lied and ignored, which then worked its way up into the lawsuit that was filed. And so this particular decision was on a motion for preliminary injunction. Try to get as you may recall, an injunction is one of the remedies here, and was found likely to show tarnishment at trial. At that, that's one of the standards for getting a preliminary injunction is, are you likely to prevail at the end of your case? And the trial court found that they were likely, so the injunction was granted, and so certainly the intent was there for them to disparage the plaintiff's mark, and so this likely is dilution by tarnishment. And then I did manage to discover that later on there was a permanent injunction, issued in the case, and after Leiden defaulted, but in 2008 the default was set aside. They were, able to claim that that they never intended to be in default. There was some mix-up. They were trying to defend themselves, and there were two cases going on this time: this trademark dilution case and a patent case between ChemDry and Leiden. And they claimed that since they were representing themselves in both cases, they were not sure. They got some sort of a mix-up. They never intended to be defaulted. But in any event, that they claimed that they had intended to put on a parody defense, trying to claim that there was parody involved in the registration here, but we don't know. There's no further proceedings that were reported, so. At this point, I just don't know, what the final outcome is between the parties. But I thought it was sort of an interesting case to talk about here today as an example of a dilution, and it's also a good reported case on just the standards for getting an injunction. So this would be a good point to say if anybody has any further questions. I know I've got one question to get back to people on once I find the answer. I do believe I know the answer, but I'm not 100% sure, and rather than say something incorrect during the webinar, I'd rather get back to you. But if at any point you've got questions, like for example, if you're watching the recording and have a good question at that point, feel free to call or email me, and I will certainly endeavor to get back to you as soon as practicable. So are there any further questions? Well, nobody seems to have their hand raised for further questions, so I think we'll cut them off for right now. And thank everybody for attending. Our next webinar, as a reminder, is coming up on March 13th, 2013, again for about half an hour on the topic of debunking copyright myths. For those of you who need MCLE credit, if you haven't already done so, please contact me and provide me your name and ARDC number. Those of you viewing the recording, please send me your name, ARDC number, and when you viewed the recording and how you did so, and I will certainly endeavor to get you credit. So I'd like to thank everybody for attending, and have a great day.